in yesterday's lecture, what did we do? We'll quickly revise what we did in the last lecture and then we'll proceed further. Okay. In the last lecture, we were done with, we were doing 299.3. We understood the concept of 299.3 and 304. We understood the concept of no excuse. Fine. We also read a case with regards to this no excuse, and then we proceeded further. After this, we went on to understand what is transfer of malice. Okay. While we were dealing with transfer of malice, I told you that it is a sort of a situation wherein the mens rea is transferred from one person to another, or it is transmigrated from one person to another. So the liability of the person who is committing the crime will be the same. It won't change. Okay. We also understood that there should not be any third-party intervention while there is a continuity of transaction. If there is an intervention, third-party intervention, in that case, transfer of malice will not happen and it will fail ultimately. This is what we understood. And the third thing that we understood was that only that much intention or that much mens rea can be transferred which the person initially had, not more than that. So the mens rea which a person originally had, only that much will be transferred. Then we went on to understand supposed circumstances. Okay. Now, suppose circumstances, I gave you two examples, and today we'll do cases relating to supposed circumstances. Okay. All the cases relating to supposed circumstances. Now it's a long discussion, but it's an important one. So, पहले समझो कि पहले तो first you have to understand the examples so that when I proceed towards the cases, you can analyze things more efficiently. The first thing that you need to understand here is that what is happening. First, there is this A. He slaps his wife. Fine. Wife becomes unconscious. He believes her to be dead. A believes her wife to be dead. He thinks that she has died. He believes that she has died. Unconsciousness. Unconscious. Okay. He believes that she has died. He believes her to be dead. Okay. So on this belief, on this supposed circumstance, he actually hangs her. Now here, when he's hanging her, the intention is to create false evidence. The intention is what? Intention is to create false evidence. Fine. The intention is not to kill a person. The intention is not to cause a bodily injury which is likely to cause death. There is no knowledge that such an act will cause death. And the intention is only to create false evidence. So he hangs and accordingly B dies here. Now, in this case, what you will do? What offense will you hold A liable? Now, in this case, what you will have to do, you will have to view the original mens rea of A. You will have to view the original mens rea of A, and you will have to connect this actus reus with the original mens rea which he initially had. And on conjoint understanding of both aspects, you will hold him liable only for the mens rea which he had. So if he had the intention, if in the initial mens rea he had the intention to cause simple hurt, you will hold him liable for simple hurt. If he had the intention to cause grievous hurt, you will hold him liable. You will hold him liable for grievous hurt. If he had the intention to cause murder, you will hold him liable to murder. If he had the intention to cause death, you will hold him liable for murder. So here, the mens rea that you will view is the original mens rea. Fine. Now, this is one circumstance that you will face in ordinary situations. You will face this circumstance. Fine. Now, this is what is known as supposed circumstances. This is what we are calling supposed circumstances. On a supposed circumstances, this fellow is doing an act. So, लग रहा है कि ये ऐसा हुआ है. So, he is doing an act. So, this is something known as supposed circumstances, wherein the mens rea is actually taken from the initial act. You are taking mens rea from the initial act, connecting it with the later actus reus, and you are creating a criminal liability. Fine. पीछे का mens rea लेके आगे से actus reus लेके आप एक criminal liability create कर रहे हो. ठीक है? So in this case, what will be the criminal liability? Because the actus reus is definitely more than the mens rea which he had. So the liability will be only what the mens rea he had. You cannot overboard it because you cannot hold him liable for that act which he had no mens rea. Right? So the liability will be only of the mens rea which he had. So in this case, the liability, since he is slapped, so the liability will be of simple hurt. ठीक है? Is this clear? ये clear है यहाँ तक?
Yes sir.
ठीक है. लिखना चाहोगे ये या आगे बढ़े पहले? Yes इशिता.
सर कल आपने लिखवाया था थ्योरी ऑफ सपोज सर्कमस्टांसेस के आगे ओरिजिनल मेंस rea प्लस फाइनल कॉन्सिक्वेंस.
हाँ, तो
बट फाइनल कॉन्सिक्वेंस डजंट मेक एनी डिफरेंस नो, बिकॉज ओरिजिनल मेंस rea मुझे वो समझ नहीं आया, क्योंकि एक्टस रियस उसमें ओरिजिनल मेंस rea के हिसाब से जो होता है हम उसकी पनिशमेंट लायबिलिटी डिसाइड करते हैं ना. फाइनल कॉन्सिक्वेंस से तो नहीं फर्क पड़ेगा.
फाइनल कॉन्सिक्वेंस से नहीं फर्क पड़ेगा, बट फाइनल कॉन्सिक्वेंस लायबिलिटी एक तरह से एक्टस रियस जोड़ रहा है ना. लायबिलिटी आप क्रिएट कर रहे हो ना, उसको जोड़ रहा है ना वो एक्टस रियस. तो इनिशियल मेंस rea आप 5 उठा रहे हो, एक्टस रियस मान लो यहीं से उठा रहे हो, बट यू आर नॉट होल्डिंग हिम लायबल फॉर दैट एक्टस रियस, यू विल होल्ड हिम लायबल ओनली फॉर द मेंस rea व्हिच ही हैड. उससे ज्यादा नहीं करोगे.
So in a way ओरिजिनल मेंस rea ही है which is determining factor.
Yeah.
Okay sir.
Original mens rea is the determining factor. So ये लिखो. So in such cases, since the accused after the victim becoming unconscious did the act this is act C, did the act in the belief that the victim is dead an additional mens rea cannot be imputed. An additional mens rea, एक second, this is additional. An additional mens rea cannot be imputed. Additional mens rea cannot be imputed upon him. Rather at the most original mens rea can be extended up to the point of causation. Point of causation of death. ठीक है. Here it was the accused only. Here it was the accused only who ultimately caused death. Caused the death. ठीक है. And if the original mens rea was that of culpable homicide, or murder, then he will be liable for culpable homicide or murder. Then he will be liable for culpable homicide or murder. Homicide or murder. Original mens rea मतलब culpable homicide और murder का है, and end में murder ही हो रहा है, तो he'll be held liable for culpable homicide or murder. ठीक है. But if the original mens rea, if the original mens rea was for a lesser offense, then he will be held liable for that offense. Then he will be held liable for that offense. ठीक है, ये क्लियर हो? क्लियर हो?
Yes, sir.
ठीक है. Yes, Bhuvita.
Sir, in the first paragraph, you said that the original mens rea can be extended up to the point of causation of death. So, how it will be extended, sir? If the original mens rea was not to cause death or culpable homicide, it was of simple hurt in this case.
So they'll be held liable for simple hurt. No? Third point will be applicable. But if the original mens rea was a lesser offense, that is simple hurt or grievous hurt, so he will be held liable for that offense.
Okay, so like that line means that we should link the original mens rea and the cause of death, and if according how they match, he will be punished.
Yeah, you'll have to decide as per mens rea. Mens rea will be the deciding factor.
Okay, sir.
Okay. So now you have two situations which you guys have rightly pointed out, and which this line states. Now, what are these two situations? Now, the first situation is when the original intention. This is clear, right? यहाँ तक clear हो ना?
Yes, sir.
आगे बढ़े? Should we proceed?
Yes, sir.
Okay. So you have two situations which are there. Now the two situations is the first situation in the cases where original intention is to cause death. Okay, this is the first scenario. Second scenario, cases where original intention is not to cause death. Original intention is not to cause death. Not to cause death. Fine. Now this has been dealt by a case known as Thambu Meli. Thambu Meli versus Reg, 1954. Okay. This has been dealt by a lot of cases, but the inception or the primary aspect was propounded in Inri Pallani Gordon. 1920. Inri Pallani Gordon, 1920. Gordon, 1920. This was Madras High Court. Full bench of Madras High Court. Fine, all the judgments are High Court. No, none of the judgments were actually. This was PC. This was Privy Council. Sorry, this was Privy Council. This is Madras High Court. Fine. Now that is the reason. Here is where we have most problems. This is very easier to understand because the approach here is commonsensical approach. Very easy to understand. Now in this case, I'll tell you what had happened in Thambu Meli versus Reg. In this case, what had happened? In this case, what had happened? There were A, B, and C. They wanted to kill a man. They had already decided. They already planned. The entire plan was in place. How we are supposed to kill him. They said that he is having dinner at this dhaba. We will kill him. We'll strike. We'll hit him with a bottle, and then we'll stab him subsequently, and then we'll kill him. First, we'll hit him on his head with the bottle. So this was their plan. This was overheard by some fellow D. Take the complete plan. Now what happened? They were unlucky. Unlucky as in the moment they hit this fellow, the moment they hit him with the bottle, he became unconscious. ठीक है. Now these guys, they thought that he is dead. Now they want to dispose of this body. They want to dispose of his body. So what did they do? They went to a cliff and they threw him from the cliff. From cliff. ठीक है. Now when autopsy was conducted of this fellow, when the post-mortem was conducted, it was found that he did not die because of that bottle hit on his head, that beer bottle hit on his head. Rather, he died because of the throw from the cliff. Okay. Now, when this autopsy came, they thought that they have a viable defense here because this fellow did not die because of this thing. So they will be held liable only for hurt. They should not be liable for the second act because the second act was actually done without any intention. There was no intention on their part. Now, in this case, the court was very clear. The Privy Council was very clear. The Privy Council said that, see, what is happening, it is impossible to divide the act. What is happening, it is impossible. I cannot divide. The judge said that I cannot divide two acts in this case. It feels that it is a series of one act only. It is a series of one act only. So if you ask me to divide this act and then divide the other, I cannot divide the act. It is a series of one act only, and I think that their intention from here should be extended to this point as well. So in this case, they had the intention right from the start to kill. So since the intention to kill was there right from the start, so that should be extended even to the point when they threw that person from the cliff. So the court clearly say that it is impossible to divide. It was impossible to divide. It was impossible to divide up. To divide. It was impossible to divide when the act is series of act. When the act is series of act. Everything is happening in series. It's very difficult to divide. So the court said that from here mens rea, you will extend it to this point. Fine. So here you will extend the mens rea to this point. And they will be held liable for murder. So they were held liable for murder. Fine. Is this clear? ये clear है? So this is the first situation.
एक बार रिपीट कर दो.
हाँ जी. क्या पूरा एग्जाम्पल?
Yes, sir.
ठीक. Yes, Aditi.
जब ये प्ली ली उन्होंने, ये प्ली में अपना मतलब ये बताया था कि उनका इंटेंशन था स्टार्टिंग से टू किल हिम, कि उन्होंने ये बोला कि हम लोग सिर्फ ग्रीवियस हर्ट देना चाहते थे.
नहीं, उन्होंने प्ली ये लिया था कि उनका इंटेंशन तो था स्टार्टिंग से, बट देन they did not have the intention when the second act was committed, which is throwing off from the cliff.
ओके सर, और अगर वो अपनी प्ली में ये चीज कहते कि हमारा सिर्फ ग्रीवियस हर्ट करने का इंटेंशन था,
तो नहीं लायबल होते.
ओके सर.
तो नहीं लायबल होते.
ओके सर.
ठीक है, बट डी ने देखा भी तो था, सिर्फ उनके बोलने से थोड़ी हो.
हाँ सर, मैं भूल गई.
ठीक है, चलिए अब आ जाओ फिर से. सो ए बी एंड सी जागते रहो. जाग रहे हो ना? इतना भी बोरिंग
Yes,
नहीं है. इतना भी बोरिंग नहीं है यार. तुम लोग ऐसे क्यों?
Very interesting.
ठीक है. A, B and C, they had the intention to cause death. Now they had the intention to cause death of this X. Fine. They went to this bar and they took a bottle and they strike it on the head of X. एक second. Okay. So A, B, and C, they had the intention to cause death of X. Okay. When they had the intention to cause death of X, they went to this bar wherein X was sitting. They took a beer bottle, and they had planned everything. They said that first we'll strike him with the bottle, then we'll stab him, we'll do so and so. They went to the bar, they took the bottle, they they started hitting on X's head. The moment they struck X's head, X became unconscious. Now they thought that he is dead. Now they had to do something when this fellow is dead. So they wanted to dispose of his body. So in order to dispose of his body, they go to a cliff and they throw his body from the cliff. Fine. End of the story, right? They throw his body from the cliff. Now, when the case comes to trial, the autopsy shows that X had died because of fall, not because of hit from bottle. Okay. So the actus reus changes, and the actus reus is not conjoining with mens rea. So here they said that they took a defense. A, B, and C, they took a defense that they said that C, we did not throw him from the cliff with the intention of causing his death. Rather, because we did not know that he is alive. So how can we have the intention to cause death? We did not intend to cause bodily injury, which is likely to cause death. We did not have knowledge to cause death. Knowledge that it is likely to cause death. So in all three cases, why are you guys holding us liable for murder? Why are you when the act which caused his death, we did not do it with the requisite mens rea? Why are you holding it liable? Now, when this case came before Privy Council, the Privy Council said that we cannot divide these two acts. We cannot divide the hitting of bottle and his throwing, his fall, in two different proportions. We'll have to view it as a series of acts. And in this case, the original mens rea which these guys had, which was the intention to cause death, will be extended to the subsequent actus reus. So the original mens rea was extended to the subsequent actus reus, and A, B, and C were held liable for murder. Now it's clear? Yes, Puvita.
Sir, just one clarification, sir. Sir, like if they had gone by the plan of the original mens rea, in that case also the actus reus would have been same, no, sir?
Yeah.
So in this case, the actus reus of the original mens rea and the actus reus of the thing which happens in the last should be same. When they are same, only we could extend the mens rea to the last act, no, sir?
You can extend it in both cases, but the liability will depend upon the mens rea. We are extending in both cases, na? We are extending mens rea in both cases. We are extending even when the original mens rea is not to kill. So original mens rea is not to cause death. Even then we are extending mens rea, but the liability in both cases is dependent upon the mens rea, original mens rea. That is the first initial mens rea. Fine.
Sir, but in second case, in the second situation, he'll be only liable for the actus rea which would have been caused by the original mens rea, sir.
Yeah, that is
So,
what I'm saying.
Sir, but in this case, for that to happen, I'm telling the possibility, sir. The possibility of the actus rea which would have been caused by the original mens rea and the actual actus rea should be same.
In this case,
for the first situation.
Yeah, true.
Okay, sir.
Correct. So here you are holding him liable for murder. Fine. This is the first possibility, which was dealt by the Privy Council in this case, and the defense was not provided. This is Thabbu Meli versus Reg 1954 Privy Council. Now the confusion which generally arises is not with this first set of circumstances, because the first set of circumstances are easier to interpret because the mens rea is same, the act ultimately is committed. So you can say that, okay, fine, there is a series of acts, so you can hold them liable. The problem arises is when we are dealing with the second set of facts. Now, what are the second set of facts? And those are the important ones. Now, this case came into light in Pallani Godan for the first time in 1920. Now, this is not a, mind you, this is not a Privy Council judgment. So that is the reason we cannot take it as reliable as the other one, Thambu Meli. It's a High Court judgment, Madras High Court for that matter. But having said that, it is not that they are propounding a wrong law. The law is on point. But the law has varied from this, what was held in the Pallani Godan. Law has extended. The base has been the same. The base has been what is held in Pallani Godan. The law has changed slightly in subsequent cases because we have more circumstances coming into picture. But the base which is provided in Pallani Godan is same. Now, what is the circumstances in Pallani Godan? Yes, Samjit. Yes, Sejal.
So both the cases are the adjudication of High Court.
No, the first one was Privy Council. ठीक है, तो अब आ जाओ इस पे इंद्री पल्लनी गोदन मद्रास हाई कोर्ट इंद्री पल्लनी गोदन मद्रास हाई कोर्ट फाइन अब देखो दिस इज 1920 केस फाइन अब इसमें क्या हुआ था व्हाट हैड हैपेंड इन दिस केस ए strikes H husband and wife. In this case, H strikes W with a plowshare. ठीक है. Now the intention of H was to cause grievous hurt. He intended to cause grievous hurt. ठीक है, उसका प्लॉशेयर से अटैक किया. Then the intention was not to cause death. Intention was to cause grievous. W became unconscious. Fine. And what did he do? In order to create false evidence, in order to save himself, he hangs W. ठीक है. W died because of hanging. Now in this case, what liability you will impute upon H? ये बताओ. Tell me.
So grievous hurt.
हाँ. Yes, Mansi, बताइए.
Sir, grievous hurt only, as original intention was to cause grievous hurt.
ठीक है. Yes, Anshika.
Yes, sir. Same, sir.
Everyone same? Anyone
Yes, sir.
differing?
So same, grievous hurt.
ठीक.
Yes, sir.
So in this case, grievous hurt, you will hold him liable for grievous hurt. There will be a mens rea from here will be extended to this act. The mens rea was to cause grievous hurt, so the liability will be of grievous hurt. But now the story does not stop here. Pallani Godan was not the end of this concept. Most people think that Pallani Godan is the end of this concept. In fact, this is the initiation point. इसके आगे तो बहुत चीजें हुई हैं. One judgment after the other, but इसके बाद जो judgment है वो बहुत interesting है. And that judgment is by Rajasthan High Court. Murder can't be committed against a dead person. Definitely. अब आ जाओ Rajasthan High Court. Now what does Rajasthan High Court say? Wait एक second. केस का नाम था बुद्धा versus. Yes, Ishita.
So striking a person with plowshare, won't it be imminently dangerous to cause death?
No, it is not imminently. In this case, the injury was not fatal.
Okay.
Injury in this case was not fatal. That is the reason the court said that since the injury is not fatal, we cannot say that it is likely to cause death.
Okay.
The second is Buddha versus state. उसका टेंशन मत करो इशिता. That is challenged. That question is challenged. Writ file हुई है 3 दिन पहले.
So which one? हरियाणा के लिए?
हाँ.
Okay, sir.
ठीक है. तो नहीं उसमें murder will not be the answer. Culpable homicide can be. That they have considered. अब मैं बताता हूँ क्यों. Buddha was a state. This was by Rajasthan High Court, and this was also a full bench. Rajasthan High Court, and this was a full bench. And this is where the story changed. अब story इधर कैसे change हुई ये समझो. Here what had happened? There were 3 friends, A, B, and C. They were sitting in a tea stall. चाय की दुकान पे, normal टपरी होती है, वहां पे बैठे थे तीनों. They were sipping tea. Suddenly what happened? B became unconscious. ठीक है? Now, A and C, ideally, when someone becomes unconscious, what is their duty? Duty is to check pulse, check whether he is breathing. They checked his breath. They did not check his pulse. They did not go to a doctor. They did not call any physiotherapist. They did not do anything. They thought that this fellow is unconscious. Let's bury him. Look, guard it. Let's bury him. So what did they do? He and A, along with other friends, they went to a quarry and they buried B. Okay, they buried B. Now, ultimately, when they buried B, B did not die because of anything happened or because of unconsciousness or something. Anything. B died because he was buried in a quarry and there was a lot of chemicals. So ultimately, he died and he was suffocated there. Fine. So now, what happened? Police, whenever such a thing, any accident happens, you'll have to file a police report. After burial, they went to file a police report. Police officer said that I will have to check the body whether it is actually an accident or whether it is some wrong has been done. So they said that we have buried the body. So he said that, okay, fine, I'll take the permission from magistrate and I will disinter the body. Means that I will disinter body, meaning that I will take that body from the ground and I'll actually examine it. So the body was disinterred. They conducted an autopsy and the doctor said that he died because of burial. Fine. Now the question was of their liability. FIR was filed against A and C. Now the question was of their liability and a few other members also who did not check. So the question was of their liability. What liability should we do? So in this case, the court held that we cannot rely on Pallani Godan. The reason being, in that case, first an act was committed, then unconsciousness happened, and then believing a person on the supposed circumstances, hanging had taken place. So we could impute the initial mens rea with the later actus reus. Here, initially there is no mens rea. How will you impute? Zero mens rea in the initial stage. They were sipping tea together. They did not have the intention to kill any person. Suddenly one person becomes unconscious. So they said, how do we deal with such a situation? So the court said that, see, even though there is no mens rea, there is a sense of recklessness and negligence. Ideally, they should have checked the pulse. They should have gone to a doctor. They should have informed the doctor. They should have at least checked the person before burying him. So the court said that this is a case of death by negligence. So in this case, there is a clear case of negligence. So therefore, A and C were held liable for 304A of IPC. Yes, Aditi.
सर बेसिकली उन लोगों ने उसको टी स्टॉल से उठा के बरी कर दिया, मतलब उसकी फैमिली को कुछ भी नहीं बोला, मतलब
ताया बाबा को बुलाया उन्होंने, बोला कि
मतलब तो उन लोगों ने भी चेक नहीं किया, उसको डायरेक्ट उठा के बरी कर दिया.
नहीं, पुअर गाय. तो ये हो गया. So he died. So ultimately they were held liable for negligence. Just 304A. It was your duty to at least check his pulse, at least get him to a doctor. So it was their duty. So they were held liable. Death caused by negligence. सजा ज़्यादा नहीं है. The punishment is up to 2 years, but they were held liable for this offense. Now here what happened, this was the first case where we drifted slightly from Pallani Godan and we created a liability for someone. So this is when the courts actually realized that we can actually impose liability even in such cases. if there is a situation of recklessness, if there is a situation of if there is a situation of panic, and because of panic that person forgets to check the pulse, or he forgets to check the breathe, that whether the person is breathing, and directly goes and hangs that person, in that case the court said that we can actually impose liability. Now the question that arose was, what sort of liability you will impose, कि कितने हद तक आप liable करोगे, whether you will hold him liable for negligence or whether you will impute knowledge upon. मतलब दो चीजें हो सकती है. Either a person can be held liable under 299(3), wherein you are saying that you did not even check the pulse of that person, you did not even check whether he is actually dying, and you just hanged him. So the court can say that, we can say that you had the knowledge that if I act in such a manner, death may be the consequence. So here the court is imputing knowledge because of a sense of negligence. So this negligence will not be an ordinary negligence, this will be a higher negligence. So when a case comes of higher degree of negligence, so you will impute knowledge. Okay? But there can be a case which is a case of lower negligence or recklessness. ठीक है, छोटा केस हो सकता है, छोटी नेग्लिजेंस है, जैसे इस केस में इन्होंने छोटी नेग्लिजेंस कर ली, मान लो कि it can be a lower degree of negligence, it's not a panicky situation, they waited for people to come, everyone saw he was not breathing, but they did not get the doctor. मतलब छोटा degree of negligence, this can also happen. So when it comes to a lower degree of negligence, then you can hold him liable for 304A, lower degree of negligence. Okay. Now what will happen if there is no negligence? If there is no negligence, then in that case you will hold them liable for the original offense, original mens rea. Then you will impute original mens rea. ठीक है, ये क्लियर है? यहां तक क्लियर हो? चाहे पिला के बरियल कर दिया.
Sir, what is written 299 clause?
3.
Okay.
3 में तो नॉलेज होगा, और किस में नॉलेज है? यस चेतन.
सर नो नेग्लिजेंस हम ये भी कह सकते हैं ना कि सर्कमस्टेंसेस कुछ ऐसे थे कि वहां पे चेक करने का ड्यूटी नहीं था, जैसे प्लानिंग गुंडन में है.
हाँ, कुछ सर्कमस्टेंसेस ऐसे हैं जहाँ पर आप डॉक्टर को भी नहीं बुला सकते क्योंकि सिचुएशन ऐसी हो गई थी, तो डर के मारे यू हैड टू टेक अ स्टेप. सो इन दैट केस ओरिजिनल मेंस rea will apply.
सर वो 299(3) लिखा है ना आपने?
3 299. यस दिव्या.
सर ऐसे हर केस में नेग्लिजेंस नहीं रहेगा कुछ ना कुछ, क्योंकि ये जो हस्बैंड एंड वाइफ वाला भी आपने एग्जांपल दिया था, उसमें भी हस्बैंड चेक कर सकता था पल्सेस एंड ऑल जो भी.
डेफिनेटली चेक कर सकता है, डेफिनेटली चेक कर सकता
तो
है.
ये नो नेग्लिजेंस वाला केस कौन सा हो सकता है?
नो नेग्लिजेंस वाला केस हो सकता है कि wherein he himself has checked, he himself is sure of it कि यार she is not alive. ऐसा भी हो सकता है कि जहाँ पर पल्स भी नहीं चल रही है, ब्रीदिंग भी नहीं चल रही, and the wife has some disease or another, so he said that she is probably dead, so he hangs her. ऐसा भी हो सकता है. It can be a no
सर
negligence.
ये हायर नेग्लिजेंस एंड लोअर नेग्लिजेंस वाला एक बार रिपीट कर दीजिए प्लीज.
हाँ जी, ये रिपीट करता हूँ. यस अंशिका, पहले बताइए.
Sir, the case that we discussed just before Buddha versus State, sir, in that case, why they are not liable under higher degree of negligence? Because there was no safe, like they didn't check the pulse and anything, and we are making them liable under lower degree of negligence, where you told that there are something that is being done.
Yeah, there's something. Why they are not being held liable for higher degree of negligence, you are saying?
Yes, sir, because they didn't.
They checked breathing. They did not check the pulse. A lot of people were there. They started claiming other things and they started checking. So they did the preliminary checkup, but वो जैसे डॉक्टर के पास नहीं गए. That was needed in such circumstances.
Okay, sir.
Yes, Sejal.
सर एक बार बुद्धा वर्सेस स्टेट का हेल्ड आप लिखवा देंगे क्या?
हेल्ड मत लिखो, उसका हेल्ड मत लिखो, बट लिखना है क्या आपको? डू यू गाइस वांट टू राइट? मैं उसका उसके बाद वाला जो केस है उसका हेड लिखाना चाह रहा था.
ओके सर.
ठीक है, आई विल राइट इट इफ यू वांट टू. आई कैन मेक यू राइट इट, बट फायदा नहीं है, एग्जाम में भी नहीं आता.
ओके सर, नेक्स्ट वाले का लिख लेंगे.
हाँ, यस इशिता.
Sir, can a doctor be held liable under this 2993 because of higher degree of negligence if he declares a person dead and the person is not?
Yeah, he can be held.
Okay,
जैसे डॉक्टर की लाइबिलिटी हम क्रिमिनल में कम इम्पोज करते हैं, बिकॉज डॉक्टर हर हम एक्सपेक्ट नहीं कर सकते डॉक्टर एकदम ही परफेक्ट काम करे, तो हम कोशिश करते हैं कि कम हो.
So, but still, seeing the profession, we can impute knowledge on doctor, right?
We can impute knowledge on doctor, but हम इतना इम्पोज नहीं करते बिकॉज हम चाह रहे हैं कि कम लाइबिलिटी हो. We'll study that in Jacob Matthew.
Okay, sir.
कि हम कोशिश करते हैं कि डॉक्टर की लाइबिलिटी इतनी ना क्रिएट करें. Only in 3 cases we create a liability when the act is manifestly negligent.
Okay, sir.
On face ही लग रहा है बहुत ही negligent.
Okay, sir.
तो ये हो गया 299(3) में when there is a higher degree of negligence तो आप impute कर रहे हैं knowledge. Lower degree of negligence we are imputing 304A. No negligence original mens rea. अब ये स्टार्ट कहाँ से हुआ, ये गेम स्टार्ट कहाँ से हुआ, ये वाला जो मैं बोल रहा हूँ, ये 3 चीजें. In which case it was held, these 3 things. These 3 things were held by a full bench in Sarthi versus State of Madhya Pradesh versus State of MP. अब इस केस में क्या हुआ था, and that is the reason you will have to, whenever this question comes in MP, you will have to write the answer as culpable homicide not amounting to murder. So इस केस में ऐसा क्या हुआ था, this is a 1975 judgment. And this is by MP High Court and it's a full bench. Full bench में अब जो the person who wrote the judgment, he is very important because he is the one who we refer him for drafting. That is GP Singh. Whenever the time comes, we refer him for drafting various for interpretation of statutes. GP Singh and ML Malik were the 2 judges. Yes, Ishi, बताइए.
Sir, how many judges are there in a full bench?
2 judges.
Sir?
Supreme Court में 3, in High Court 2.
High Court 2?
High Court 2.
Okay, sir.
अब आ जाओ. ठीक है, this is a 2, sorry 3 judges है ना full bench 3 judges है. क्या बोल रहा हूँ, 3 judges. हाँ, 2 division है, ये division bench थी, sorry. ठीक है, सारथी वर्सेस स्टेट ऑफ एमपी. अब आ जाओ, इसमें क्या हुआ था. अब इसमें क्या हुआ था, what had happened, A, B and C, they were hitting W. Fine. Ultimately, W became unconscious. They got very scared. They hanged her. And she died. They hanged her, and because of hanging, she died. Now, when the case came before the court, the question was, what will be their liability? Now, in the manner they were hitting, it appeared that they had the intention to cause grievous hurt. Intention to cause grievous hurt. In the manner they were hitting, they had the intention to cause grievous hurt. Now, the question was, what liability you will import? So, in this case, before GP Singh, Inri Pallani Gordon was presented. And the court was asked to rely upon this judgment and hold A, B, and C liable for grievous hurt. Fine. Now, GP Singh distinguished these facts from Pallani Gordon. GP Singh said that there can be 2 circumstances. The first is when the original intention is to cause death and the ultimate consequence is death. In those cases, we don't have problem. And then there is this case when the original intention is to cause some lesser crime, and as an actus reus, death is caused. JP Singh says that we'll have to be careful in this. We are not supposed to extend the mens rea arbitrarily or as per our whims and fancies. We'll have to examine the case carefully. Now, in this case, we will have to examine whether there is any recklessness while they are believing her to be dead. Okay. See, a belief in good faith, if there is a belief in good faith, then you can extend the mens rea. Agar belief in good faith hai, you can extend the mens rea and they will be held liable for intention to cause. If there is recklessness, and if the recklessness is of higher degree, if there is recklessness and recklessness is of higher degree, in that case, you will hold them liable for 299(3), which will be punishable under 304. If the recklessness is there and the negligence is of lesser degree, then you will hold them liable under 304A. But wherever there is recklessness, you will impute knowledge. You will say that since I am acting in such a manner, I have knowledge that this will happen. Since a person is acting in such a manner, he has knowledge that he is acting, that this will happen. So on the basis of this, A, B, and C were held liable for 304 part 2. That is culpable homicide not amounting to murder. Homicide not amounting to murder. Okay. Yes, sir, Simran.
Case of Buddha versus state, these people were held liable under 304A. Why not 304 to part 2?
Part 2, because the degree of negligence was not higher enough. The court held that in that degree, actually everyone saw, everyone checked the breath and all. So the degree was not, they tried to check, but they were not thorough enough. So the degree was lesser degree of negligence. ठीक है
सर मतलब फैक्ट्स में ये कहीं ना कहीं रहेगा कि उन्होंने कितना नेग्लिजेंटली बिहेव किया
नहीं ये नहीं रहेगा ये नहीं रहेगा ये नहीं रहेगा इसमें एक चीज है इसमें बस ये समझ लो कि if you are writing in your preliminary if there is preliminary PT में अब how do we deal with this question if there is in PT in Haryana and MP the answer will be culpable homicide not amounting to murder. They will give you the same facts as Pallani Gordon probably. The answer will be culpable homicide not amounting to murder. ठीक है? In other states, any other states, in all other states, the answer will be simple hurt or grievous hurt depending upon the facts. Suppose it is a slap. In most cases, they'll ask you slap. So that will be simple hurt. If it is a plowshare, that will be grievous hurt. If it is an iron rod, then it can be a murder also. Okay? So it will be depending upon the weapon that is using. So in most cases, they'll ask you slap or plowshare. This is the general MCQ that keeps coming. Fine. This all, whatever I have told you, this you will have to write in mains. ठीक है ऑब्वियसली प्री में तो लिख नहीं पाओगे यही आपके पास ऑप्शन है यस अदिति
सर दोनों हायर और लोअर डिग्री में वी विल इंप्यूट इन बोथ केसेस
हाँ जी हाँ अदिति
ऑडिबल
क्या है ऑडिबल
सर आई एम आस्किंग दैट in both higher and lower degree we will impute knowledge in these both cases or
no
only
in higher degree we impute knowledge only in higher degree
okay sir
ठीक है yes सेजल
सर हमने जो डिग्री ऑफ नेग्लिजेंस की टेबल बनाई थी उसमें हायर डिग्री ऑफ नेग्लिजेंस में हमने 299(3) लिखा था
हाँ जी करेक्ट
तो फिर एमपी में 300 एंड पार्ट 2 में क्यों कर दिया उन्हें
300 ये इसकी लायबिलिटी 304 में ना 304 पार्ट 2 में ना वो तो डेफिनेशन क्लॉज है डेफिनेशन क्लॉज ये पनिशेबिलिटी ठीक है
ओके
so because of this story your answers in different states vary had this story not been there your answers would have been this ठीक है, because of this small story your answers in these states vary. ठीक है, ये क्लियर है? यस चित्र।
सर मेंस में भी इन सभी स्टेट्स का अलग अलग लिखना है?
नहीं, मेंस में आप सारे जजमेंट्स कोट कर सकते हो। मेंस में you can get creative, not an issue.
ओके, अगर मेंस में हरियाणा में सेम फलानी को ना दे तो हमें फाइनल जजमेंट क्या देना?
तीनों डाल दो ना। you'll have to put सारथी also, बाकी आपकी इच्छा है कि you'll see on the basis of recklessness also. You'll say that it appears from the fact that
वो हमारी रीजनिंग है, हम उसको किस तरह फील कर रहे हैं।
हाँ, yes, Anshika.
Sir, it's 304 part 2 or part 3?
Part 2, part 3 है ही नहीं, 304.
Okay, sorry.
Yes, Ishita.
सर ये इसका हेल्प पार्ट लिखवा दीजिए प्लीज, सारथी वाले केस का।
सारथी वाले का, ठीक है। वेट, एक सेकेंड, एक इम्पोर्टेंट पार्ट लिखवाना था मुझे। ठीक, एक सेकेंड दो मुझे। ठीक, so there may be 3 situations. The court held that there can be 3 situations. There can be 3 situations. 3 situations. The first is the accused may believe the victim to be dead. The victim to be dead. ठीक है, तो पहला ये सिचुएशन है। और he may be unmindful. He may be unmindful of belief. Unmindful of whether the victim is dead or alive. Whether victim is alive or dead. Alive or dead. ठीक है, so first है कि he may believe that the victim is dead. He may be unmindful of unmindful whether he is dead. And the third scenario is accused believes that the victim is alive. Accused believes that the victim is alive. Victim is alive. ठीक है, अब in the third circumstance, it is a clear case of murder. करेक्ट ना, क्योंकि उसे लग रहा है कि मान रहा है alive है, still he is hanging there. So in the third circumstance, it is a clear case of murder. However, the question, however, circumstances 1 and 2 have to be examined carefully. ठीक है, if in the second circumstances, which is he is unmindful whether the victim is dead or alive, if in the second circumstances the person hangs the accused, hangs the victim without any caution. that is checking pulse or breathing, etc. ठीक है? In that case, knowledge can be attributed. Knowledge can be attributed to upon him, and he can be held liable. He can be held liable under section 299(3). क्लियर है यहां तक? क्लियर हो?
Yes, sir.
In the first scenario, ठीक है? क्लियर? बताऊं आगे?
Yes, sir.
Yes, sir.
Sir, please show last line.
ला, रुक। देखा?
Okay, sir. Thank you.
ठीक। In the first case, if the belief of the person was on basis in the first case, if the belief of the person in the first case, if the person was negligent and he did not take necessary caution, then liability will be created. Under section 304A. The negligence under section 304A is comparatively less than 299(3), wherein even knowledge is imputed. ठीक है? क्लियर है? इस केस में क्या हुआ था? इस केस में they were unmindful of the fact that whether she is alive or dead. उन्हें बस hang कर दिया. So since they were unmindful of the fact whether she is alive or dead, they did not take necessary precautions also. They will be held liable for 299(3). ठीक है? If they believe that she is dead, but still they were negligent in actually seeing whether this fellow is dead or not, मतलब checkup भी नहीं कराया, check भी नहीं कराया, in that case the liability will be created under section 304A. Clear है? Clear है?
Yes, sir.
तो ये हो गए 3 सिचुएशंस। ठीक है, अब आगे बढ़े। उभरे सपोज सर्कमस्टेंसेस से। ठीक है, अब आ जाओ 299 एक्सप्लेनेशन 1 पे। क्या टाइम हुआ? टाइम है ना अपने पास?
सर 8:54।
299 एक्सप्लेनेशन 1 पे आते हैं। कल आपका टेस्ट है ना?
Yes,
तैयारी कर रहे हो इसकी? चलो एक्सप्लेनेशन 1 पढ़ते हैं। वो एक्सप्लेनेशन 1 पे। एक्सप्लेनेशन 1 टॉक्स अबाउट एक्सेलरेशन, जिसको बोलते हैं एक्सेलरेशन। ठीक है, it provides for acceleration. Now, what does acceleration means and how it works, that we'll understand. ठीक है, अब आ जाओ acceleration को देखो. सब आ गए explanation 1 पे.
Yes, sir.
A person who causes bodily injury to another who is laboring under disorder or disease of infirmity and thereby accelerates the death of the other shall be deemed to have caused death. Okay. If a person is causing death of any, if a person is accelerating any other person's death, so then in that case he will be liable for the death of other. For example, A is suffering from a heart attack. Okay. What do? You go and punch on his chest repeatedly. Now here, what you have done, you have accelerated his death. So in this case, you will be held liable for culpable homicide or murder, as the case may be. So you can be held liable for culpable homicide also, you can be held liable for murder also, as the case may be. Now in explanation 1, there is even euthanasia's cases falls under explanation 1. Okay, even cases of euthanasia fall under explanation 1. Now what are those cases? Suppose a person has a brain dead. Okay? And he is asking you to he's anyway supposed to die someday, and he's asking you to, his parents or someone, his relatives are asking you to just pull the plug or to take away the breathing equipment. You take the breathing equipment or you take the ventilator. The moment you take it, he dies. Now in this case, what did you do? You accelerated his death. So you will be held liable for culpable homicide, not amounting. You will be held liable for culpable homicide. It may be murder, it may not be. So you'll be held liable for culpable homicide. Fine. So any act of acceleration will amount to, any act of acceleration for that matter, will amount to culpable homicide. So even if a person is suffering and you accelerated his death, that will amount to culpable homicide. यहाँ तक clear हो? यहाँ तक clear हो?
Yes, sir.
Yes, sir.
चलो अब बात करते हैं यूथनेसिया की. अब यूथनेसिया आ गया तो we'll have to talk about it a little, ना? Right? Should we? चलो. Let's talk about it a little. आ ही गया तो एक सेकेंड. Yes, इशिता.
सर यहाँ पे इंटेंशन इन्वॉल्व होगा क्या एक्सिलरेट करने के टाइम पर?
इंटेंशन इन्वॉल्व है ना. इंटेंशन या एनी बॉडीली इंजरी व्हिच इज लाइकली टू कॉज डेथ, चाहे इंटेंशन टू कॉज डेथ ना हो, बट knowledge is there. Knowledge is there. Yes, Chetan. ठीक. अब एक सेकंड दे दो मुझे. I had something to share with you. Give me a second. तो अब यहाँ पर आए हैं तो explanation 1 we are studying, we'll have to understand the concept of euthanasia also at a greater length, right? We cannot just leave it here. So let us understand the concept of euthanasia and the laws surrounding euthanasia broadly, not in a greater detail, broadly, whatever it is. So the first thing that you need to understand here is the first case which declared a negative right was Bijoy Emanuel. Okay, was Bijoy Emanuel versus State of Kerala, which is also known as Joawa's witness case. Okay, it's a Joawa's witness case. It is a case wherein certain people of certain sect were not singing national anthem because that was It was not permitted in their religion. So the court held that if court interpreted 19(1)(a), Article 19(1)(a) in a negative sense, court said that, see, if a person has a right to speech, so definitely he will have a right to remain silent. So if a person has a right to speech, so he will definitely have a right to remain silent. This is how the court interpreted. कि अगर किसी के पास एक positive right है, if a person has a positive right, automatically with that right you can impute a negative right upon it. So if any person has a positive right, you can actually impute a negative right upon it. This is what the court actually interpreted. Now things did not stop here. The court interpreted in such a sense in Bijoy manual, but the things did not stop here. The Supreme Court also interpreted Article 21 in that sense, but not in this case, in P. Rathnam versus Union of India. P. Rathnam versus Union of India. Okay. Now, court in this case, this was 1994 Supreme Court. Now, court in this case said that, see, if a person has a speech, he has a right to remain silent. In the same way, under Article 21, if a person has a right to life, he has a right to die. Same way, and therefore anyone who accelerates his death should not be held liable. Anyone who is accelerating his death should not be held liable. And the court also struck down 309 of IPC, that is attempt to suicide. उन्होंने बोला कि this attempt to suicide is constitutionally invalid because it is violative of Article 21. Article 21. Okay, it says that Article 21, it is violative of Article 21 because if you have a right to life, you have the opposite of it, you have the converse of it, that is right to die. So, the same explanation as was held in Bijoy manual. The same logic they applied, that if there is a right, you will have the converse of it. You will have the opposite of it. So the court held that if a person has right to speech, he also has a right not to speak. Right not to speak. Okay? And similarly, if he has right to life, he has right to life. He also has right to die. If he has right to life, he also has right to die. Hence, 309 is unconstitutional. 309 of what? IPC. What is 309? 309 is attempt to suicide. So 309 of IPC, which is attempt to suicide, is unconstitutional. Okay. So this was the first case which declared 309 unconstitutional and which introduced a concept of euthanasia. It introduced a concept of euthanasia. If a person wants to die, he has the right to die. Fine. So now the concept did not stop here. The case, again, this case for 2 years, for 2 long years, what had happened? For 2 long years, ये जो 2 साल के लिए था, for 2 long years, 309 was unconstitutional. ठीक है, 94, 95, for 2 years it was unconstitutional. In the year 1996, a constitutional bench was set up, 5 judges bench, and it was presided by Justice J.S. Verma. And this was in this case. So in Gyan Kaur versus State of Punjab. State of Punjab, that is 1996. 96. It is a 5 judges bench. And it was presided by Justice J.S. Verma. Justice J.S. Verma is the same judge who was in Visakhapatnam versus State of Rajasthan, who actually framed 2013 laws for rape and sexual harassment. So he is the same person. So now in this case, what did the court do? Court said one simple thing. Court said that, what does Article 19 do? Article 19 confers a right. Okay, Article 19 is giving a right to someone. It is conferring upon a citizen that you have the right to speak. You have the right to speak. So now if the state is giving him, so you can presume a converse of it. You can say that, okay, you are giving me right to speak. That does not mean I'll keep on speaking. I can keep quiet also. But on the other hand, Article 21, interestingly, Article 21, state is not giving you. It is not conferred upon you. It starts with a negative connotation, which is no. No person shall be deprived of life and liberty. No se start ho raha. So the state is not giving you life. You have the inherent right to life since your existence itself. Aapke presence se, aapke inception se, you have the right to life. State is not giving it. In no country the state will give you life. You have your own life. Fine. Now, what Article 21 says is that the state will not deprive you of your liberty and life. So on the other hand, Article 21 is a duty upon the state that, state will not deprive you of your right. It's a declaration that state kuch nahi karega aapki life. State won't do anything to your life. So that is what the Article 21 is. It's not something which the state is giving. So if the state is not giving anything, so how can you presume a converse of it? How can you say that if the state is giving you liberty and life, so it means that there will be right to die? You cannot say that, because state is not giving you any right. State is only protecting that right. Now in that protection, you cannot include a right to die also, a negative right also. So that is the reason the court held that you cannot include right to die in this in Article 20. There cannot be a converse definition or the converse understanding of Article 21. आप उसको oppositely पढ़ नहीं सकते. It is saying that state will not deprive you life and liberty. That is what it means. ठीक है, उसको आप ये नहीं कर सकते, state will not deprive your right to die. ठीक है, that is not what the Constitution actually promised. Fine, ये right already है आपके पास and state is protecting it. So this is what the court said. Do you guys want to write this? नहीं लिखना चाहोगे ना ये तो? लिखोगे? जल्दी बताओ.
Yes, sir.
Yes, sir.
The court held that off topic नहीं है. मत समझो कि explanation से off topic जा रहा है. एकदम उधर ही आएंगे जहां पे छोड़ा था. आपको realize भी नहीं होगा कैसे आ जाएंगे. ठीक है? The court held that context of Article 19 and 21 are different. In Article 19, it is a freedom of action. It is a freedom of action. Whereas in Article 21, it is not a freedom of action. Freedom of action. Rather, it is a preservation of life. It is a preservation of life and liberty. Preservation of life and liberty. Of life and personal liberty. Life and personal liberty. ठीक है? preservation of life and personal liberty of the individual. ठीक है? Therefore, unlike Article 21, unlike Article 19, there cannot be an implicit negative of positive right. That is right to life. Sorry, implicit negative of positive right, that is right to life. Right to life. Okay, that is right to life would not include in itself the right to die. ठीक है, is this clear? यहाँ तक क्लियर हो?
Yes, sir.
ठीक. अब देखो यहाँ तक ठीक है, यहाँ तक things were going fine. One court said that there is right to die. Sir, it was also held that right to not speak is an omission, whereas dying is an act. Yeah. Right to not speak is an omission, while dying is an act. Yeah. So no one can omit a fundamental right. Yes, that also you can say. Now, now one other thing that you have to keep in mind, and this is Kyan Kaur versus State of Punjab. यहाँ तक हम clear है. Till here we have no problem. Fine. One court is saying that there is right to die. One judgment is saying there is right to die. Subsequently, that is overruled. End of the story. But things do not end here. There was this another case which was Aruna Shanbag, and this was a very prominent case. In this case, a woman was raped a long time ago in KEM hospital, and she was in a paralyzed condition, and there were no chances of her survival, and she will be dead someday. It was expected that she'll be dead someday. So what the doctor, one of her doctor, went to the court, that is Pinky Chandwani, or one of her doctor, she went to the Supreme Court, and she asked for euthanasia. She said that let's accelerate her death and allow us to do it. Now court was deciding euthanasia in this case. Aruna Shanbag versus Union of India. That is 2011. Now here judge was Justice Markande Kajju. Okay, Justice Markande Kajju. Now here, the important thing the court held here, everyone has a right to life. There is no right to death. But right to die is there, but with dignity. You can die. If you want to die with dignity, you can die. And for that purpose, the court said that there is no concept of active euthanasia. Rather, there is a concept of passive euthanasia. Now, what is the difference between both of them? See, there are two things. One is active euthanasia. One is passive euthanasia. Now, आप समझो यहाँ पर passive euthanasia. In active euthanasia, what happens? You poison a particular person, or you cause that person's death, and you end his life. Fine, a person is suffering from brain dead. You poison him and you end him. Fine. In passive euthanasia, you remove his life support. Fine. So the thing in passive euthanasia is that you are not causing his death. The person is dying because you're removing the life support. Suppose he's whatever the medicines that you are supposed to give him, you stop giving it. The life support that he's having, you stop doing that. So you are removing the moment you restrict the life support, the moment you remove the life support, ultimately that person dies automatically. Okay. Here you are doing an active act. Here you are doing an act to cause death. Either you are poisoning him, either you are doing some act. So this is what is the difference between active and passive euthanasia. Now in India, active euthanasia is not permissible. The courts do not allow active euthanasia. There is no concept of active euthanasia. Okay? It is clear that there is no concept of active euthanasia. Kuch hai hi nahi. The only euthanasia that is permissible is passive euthanasia. If any doctor supports passive euthanasia, or if any doctor removes the life support, he will not be held liable under 299 because of explanation 1. He won't be held liable. Okay? So he won't be held liable. The court clearly held in Aruna Shanta. The court said that this is a permissible euthanasia. So any doctor who is removing the ventilator or is removing the life support will not be held liable for culpable homicide. Okay? So even after reading explanation 1, he will not be held liable. This is what the court held. So the important is, लिखोगे ये?
Yes, sir.
कैसे चीजें कनेक्ट हुई? लगा आपको ये यहाँ पर पहुंचेंगे हम?
So very interesting it was from the beginning itself.
I thought that I was drifting away. मुझे डर लग रहा था कि I am drifting away.
स्टार्टिंग में सुन के मैं भी कंफ्यूज हो गई थी, ये स्पीच और ये सब क्या चल रहा है, राइट टू स्पीच.
नहीं. I knew कि आप लोग को ऐसा नहीं लगना चाहिए कि सडनली कॉन्स्टिट्यूशन में कैसे आ गए. So it has been held. It has been held that euthanasia, Aruna Shanbag, before proceeding with, चलो ये पैरा लिख दो, फिर मैं बताता हूँ आपको. एक इंटरेस्टिंग चीज है. Aruna Shanbag is the first judgment in which a शायरी was quoted. पहले दिखा देता हूँ आपको, शायरी दिखा देता हूँ. It was the first judgment in which a शायरी was quoted, and the शायरी goes like this. एक सेकंड, ये है. एक सेकंड में दिखा दूँ आपको. बोलना मत. मुझे पता है यार, मैं दिखाना चाहता हूँ. बोलना मत, तुम मेरा वो एक्साइटमेंट लेवल खराब कर रहे हो. रुको एक सेकेंड. कहाँ गया ये? वेट अ सेकंड. ठीक, यही है शायद. यही है ना? दिख रहा है आपको? ठीक है. मरते हैं आरजू में मरने की, मौत आती है मगर नहीं आती. तो मार्कंडे काटजू सिर्फ फेसबुक पर नई शायरी मारते. इवन इन जजमेंट्स यू कैन सी दिस इज द फर्स्ट जजमेंट ही इंट्रोड्यूस्ड अस टू मिर्जा गालिब. एक और जजमेंट है which is of this thing, which was of this honor killing. Even in that case he actually introduced us to Mirza Ghalib. So for people who do not understand,
ऐसे जजमेंट में ये शायरी लिख सकते हैं?
लिख तो नहीं सकते ideally, but लिखते हैं. Is that a quote? Yeah, it is a quote. For people who do not understand Hindi, it means that we are dying every day with the hope of dying. Death comes but does not come. In Hindi it sounds better. In Urdu it sounds better. So we are dying in the hope of dying, but death comes but does not come. ठीक है.
पहले कहते थे कि एक नंबर होते हैं, after 2 years.
तो इन्होंने ट्रेंड स्टार्ट किया था. दिस जस्टिस मार्कंडे काटजू started the trend of writing shairis in judgment. This is the first judgment, and in subsequent judgment also he has written. That was in honor killing. That was an honor killing. तो उसमें भी मिर्जा गालिब को ही उन्होंने कॉपी पेस्ट किया. ऐसा अलग शायर नहीं ढूंढा उन्होंने. मिर्जा गालिब ही है उनका फेवरेट. So it has been held that euthanasia, this euthanasia is not permissible. Is not permissible in India. Is not permissible in India. India. And it will be an offense under section 299 or 300 of IPC. Fine. The court divided euthanasia into two parts. The court divided euthanasia into two categories. Into two categories. The first being active euthanasia. Active euthanasia, that is wherein a person does some act, wherein a person does some act to kill another person. Okay. Here the accused will be liable for culpable homicide. Homicide or murder. आप लोग मत लिखना शायरी अपने जजमेंट्स में, और ना ही जजमेंट राइटिंग में मार्क्स कटेंगे. ठीक है, मैं आगे बोल दूं, कोई आप में से कोई पूछे कि सर हमको अलाउ नहीं करेंगे एग्जाम में, अलाउ मत करना, ये कटेंगे मार्क्स, सीरियसली कटेंगे. ठीक है. So will be liable for culpable homicide or murder. Or the case may be, as the case may be. Sorry, culpable homicide or murder as the case may be. अब इसमें एक important part है, irrespective with consent or without consent. Irrespective, it was done with consent or without consent. With consent or without consent. If it is active euthanasia, तो end of the story. ठीक है. अब आ जाओ पैसिव. पैसिव में पैसिव euthanasia. Passive euthanasia, the accused does not do any act, does not do an act to kill, kill a person. Rather the life support system on which the victim is surviving is withdrawn. And the victim is left, and the victim is left to his destiny, upon which which the victim upon which the victim dies. Victim dies. ठीक है. Now आप
सर
देखो,
यहाँ पे विक्टिम की कंसेंट तो मैटर करेगी ना.
अब उस पर आते. अब देखो, the court held that the passive euthanasia is permissible and it won't create a liability under 299 3 or 299, any of the clauses of 299, even after reading explanation 1. So this is what the court held. अब important चीज है कि what about the consent? In what cases you will have to take? So the court said that there can be two things. How passive euthanasia can work. Passive euthanasia is permissible and passive euthanasia कैसे कर सकता है काम? So passive euthanasia can work voluntarily, wherein the consent is taken. ठीक है, voluntarily. So passive euthanasia will work voluntarily. In such cases, it will work with the consent of the deceased, with the consent of the victim, the person who is dying. ठीक है? And if it is done with the consent of the victim, then it is not an offense. Then it is not an offense. Not an offense. Not an offense. ठीक है? अब दूसरा होता है involuntarily. Now involuntarily is without consent. Now wherein the parent, spouse, or some family members of the deceased of the victim feel that this fellow will die soon. So now no point in keeping him alive. So that is now, but the person cannot speak. Say he's brain dead. He's in coma for a long period of time. We are certain that he will die. What is the point of keeping him alive? So this is a case of involuntarily. Now in this case, it is without the consent of victim. Now if it is without the consent of victim, there are certain safeguards which have to be followed. That is very, very important. So, but if it is involuntarily, that is without the consent of victim, then it will be allowed only if certain safeguards are followed. सिर्फ ये safeguards जो बता रहा हूँ, if these are followed, then only the euthanasia will be allowed. So these are the safeguards. The first safeguard is, यहाँ तक clear हो?
Yes, sir.
Voluntarily passive euthanasia with the consent of the victim, then it is not an offense. Involuntary, if it is involuntary without the consent of victim, then it will be allowed only if certain safeguards are followed. Okay.
Sir, this voluntary part I'm not getting. How can a person take a consent of a person who's on life support already?
You can take, na, if his hands are able to move, तो आप उससे मांग सकते हो ना consent. उसके हाथ चल रहे हैं. You are writing a form.
Because I think.
But this rarely
happens.
This rarely happens.
It's not possible. We cannot take a consent. A patient of this stature is kept in sedation all the time.
अच्छा, you are saying that he's kept in sedation? No, not necessarily. सारे time sedation पे नहीं होते. Some person, देखो, वो मैं बाद में बताता हूँ कि क्या सीन होता है. There are 3 things. मैं आप थोड़ी देर बाद बताता हूँ. ये पहले समझ लो. Involuntary समझ लो. तो ये involuntary समझ में आ गया. If it is involuntary without the consent of the victim, then it will be allowed only if certain safeguards are followed. Now, what are those safeguards? Those safeguards are very important. The first is the parents' spouse or other close relatives, the doctors and the doctor's taking care of the victim, doctors taking care of victim, doctors taking care of victim may apply to the Chief Justice of the High Court. ऐसे ही नहीं, Chief Justice of the High Court. ठीक है? Then what will happen the moment they apply Chief Justice of the High Court? Chief Justice will appoint the committee. Appoint the committee of two sitting High Court judges. High Court judges who will consult three reputed doctors. So committee will be appointed of two sitting High Court judges who will consult three reputed doctors. And only if it is permitted by the committee, such passive euthanasia will be allowed. Euthanasia will be allowed. Otherwise, it is an offense. क्लियर है? यहां पर कमिटी में देख रहे हो कौन कौन है? कमिटी में पहले तो कमिटी कौन अपॉइंट कर रहा है? चीफ जस्टिस ऑफ द हाई कोर्ट इज अपॉइंटिंग, एंड हु आर टू सिटिंग हाई कोर्ट जजेस आर देयर who are consulting first three reputed doctors. Only if these three reputed doctors allow, then only you will go for passive euthanasia. So these members, parents, spouse, other close relatives, doctors taking care, may apply to the CG of High Court. Fine. Now, why you are applying? Because the person who is the victim, he hasn't given you there is no consent from his side. So in that case, you will have to apply to the High Court, CG High Court. ठीक है? Is this clear? यहाँ तक?
Yes, sir.
Yes, sir.
ठीक है.
Yes.
Wait. Acha, see, back then I'll tell you there is a story which I want to share also. Yes, Puvita.
So it's a logical doubt, sir. I've understood.
Ask us.
Sir.
Ask
But there are situations where it is not possible for the family to pay for the expenses of keeping that person alive, no, sir. In that cases, what will happen, sir?
See, I'll tell you a trick. Now, this is a flaw in the law, and because it is a flaw in the law, doctors use it a lot, and many people have used it. Now, how does the flaw go? I'll tell you. Now, under IPC, when they talk about life, they mean to say that all the organs of a human body should come to an end. Then only a person is dead. So when they talk about life and death, it means that the person has ceased to live completely, meaning all the organs have been dead. Fine. Now, this is what our law says. Most laws, IPC and other laws also. But there is one law which does not say this. That is Transplantation Act, Transplantation of Organs Act, which says that the life ceases to exist when any of the three triangles come to an end. Now this is slightly off topic. Those who want to leave, they can leave. आज मुझे इतना ही पढ़ाना था. I can continue tomorrow. 9:35 होगा ना anyways. Those who want to listen, they can listen. See, this is what the law says. Now, what the medical science says that a human is alive because of three things. It is known as triangle of life. First is the brain, second is heart, third is your respiratory system, which is lungs. Okay. If any of these three things have been affected beyond repair, मतलब ऐसा हुआ है कि there is no chance of transplantation, there is no, it cannot be repaired. In that case, the medical science says that a person is dead. Suppose a person is brain dead, only heart and lungs are working. According to law, he is alive. According to medical science, in fact, the doctors will go to an extent where they will say you that he is not alive, but the law says that he is alive. If a person's heart is ended for a brief moment of time, he is alive, then he will die. कभी तक तो आप उसको उस पे चला रहे हो, the equipment that they use, उस पे चला रहे हो. For a brief period of time, he will be alive and he will be dead. So this is what the medical science says. This is known as triangle of life. So any part of this is what do you call? Is defected beyond repair, and you cannot transplant it, or you cannot bring, or you cannot add it, make additions to it. The person is dead as per medical science. Even doctors will say that he is dead. Okay. And this definition of dead has been imputed in Transplantation Act. So the person says that if a person is dead, meaning that any of these organs has completely terminated and it is beyond repair, in that case, you can transplant his other organ. So meaning that if you want to, suppose this fellow is alive and alive as per law, meaning that he's brain dead, his heart and lungs are working. So what you can do, you can call the doctor, you can tell them that I want to opt for transplantation. And because you can do, being a family member, you have the authority, you can do. Only in that case, transplantation only, the doctors are allowed to pull the life system for the brief period of time. And during that period, the person dies. So this is what happens in generally. No one goes for passive euthanasia. No one goes for CGI because there is a flaw in the law. Most people take benefit of this flaw. Now, having said that, whether this can be misused, the answer to this is no. This cannot be misused. I'll tell you the reason. Because if a heart or a lung, any of these three elements, any of the triangle of life ceases to exist, and you do not have a replacement to it, so the person is actually dead. There is no point on keeping him alive. In reality, it is dead. It's just that law, and for the purpose, a person is breathing for quite some times, you are feeling that okay, he's alive, he has slight chance of recovery, but no, he is dead. So the idea is it's better to accept it. So now this for transplantation, you don't have a whole day or you don't have a whole month or so. For transplantation, they give you a window when the person is brain dead. For example, I shouldn't say that, but one of my friends was brain dead. And what had happened? So he was brain dead. So the doctor had given us a window of say 3 days, that whether you want to go for transplantation or you want to keep him on life support. So say if we would have chose a life support, then what would have happened? If we would have chose life support and a week would have passed, so his organs would start depleting. So वो transplantation like होती ही नहीं. You could not transplant a depleted organ. So in that case, we could not take the benefit of that act also. So ultimately, we had to go for passive euthanasia. That was a long run. So this is what they do in generally. If you go to a good hospital, they will advise you this. Fine. Clear? Yes, Ishta.
Sir, I have 2 doubts from active euthanasia.
Pooch.
So one of them is it applicable only in those cases when the person is in like permanent vegetative state?
Yeah, permanent vegetative state, both of them.
Okay, sir. And so second question is कि उसमें in the last point is written that here the accused will be liable for culpable homicide or murder, as the case may be, irrespective it was done with consent or without consent. So, sir, if it is done with consent, so will it not?
Exception 5.
Yes, sir.
Exception 5 if he is above 18 years. You're not taking that into consideration.
So in that case, culpable homicide.
As the case may be. If he's above 18.
Okay,
So
sir.
if the contents of this exception 5 are met. Yes. Yes.
यस सर, जो आपने अभी बताया सर, इसी वजह से सर जो केसेस होते हैं जिसमें देयर इज नॉट अ चांस ऑफ अ पर्सन टू लिव, तो उसमें वी डू नॉट गो टू कोर्ट्स सर बिकॉज ऑफ द मेडिकल ट्रांसप्लांटेशन एक्ट, जिसमें जो मेडिकल साइंस की बात की गई है।
हाँ, तो उन्होंने स्ट्रेट अवे तभी बोल दिया ना कि इफ द डॉक्टर डिक्लेयर्स दैट ही इज अनफिट तो यू कैन गो फॉर ट्रांसप्लांटेशन। यस सर, सिंपल।
सर पहला डाउट तो ये था कि जो ये डॉक्टर सजेस्ट करते हैं, मतलब हाउ डज दिस थिंग गो, जो मेडिकल वाला है। आई हैव अ प्रैक्टिकल जो मेरे नोन में ही हुआ था कि किसी के ब्रेन क्लॉट हो गया था उनके, तो द फैमिली डिसाइडेड कि लाइफ सपोर्ट सिस्टम हटा दें, और मतलब उनकी डेथ उसके बाद भी नहीं हुई, लाइफ सपोर्ट सिस्टम हटाने के बाद भी काफी देर तक ही वाज अलाइव, एंड आफ्टर ब्रिंगिंग हिज बॉडी टू होम वो उसके बाद भी वो जिंदा थे, फिर बहुत देर बाद उनकी डेथ हुई। तो सर इस केस में मतलब कल्पेबल होमिसाइड होगा या फिर ये यूथेनेशिया?
नहीं, it won't be a euthanasia अगर ट्रांसप्लांट आपने किया है, and if the doctor says that ट्रांसप्लांट, अगर I suggest that उन्होंने ट्रांसप्लांटेशन ही किया होगा, मतलब as per my knowledge उन्होंने ट्रांसप्लांटेशन ही किया होगा। Otherwise the thing is that otherwise they do not allow, even if he pulls the life support तो he will be held liable।
ओके सर, एंड सर सेकेंडली मैंने एंड के लिए रखा था, ये थोड़ा सा आउट ऑफ बॉक्स है सर, जो राइट टू लाइफ जैसे हमें मिला है, वैसे राइट टू डाई क्यों नहीं है? इसका ऑब्जेक्टिव क्या है? मतलब सुसाइड कर रहा है कोई, वो उसकी खुद की पर्सनल चॉइस है।
पर्सनल चॉइस है, बट आपने राइट टू, हमें स्टेट ने नहीं दिया ये राइट, तो हम इसका कॉन्ट्ररी तो प्रिज्यूम नहीं कर सकते। अगर स्टेट ने दिया नहीं है एक चीज तो वो ले कैसे सकती है वो चीज?
बट सर स्टेट कहाँ ले रही है? अगर स्टेट
नहीं ले रही, बट वो कैसे, वो डिप्राइव भी कैसे कर
ओके, तो वो सर मतलब ये इस प्रिंसिपल पे चल रहा है कि गॉड ने क्रिएट किया है तो फिर एंड भी वही करेंगे।
एंड ही वैसे चल, हाँ, मतलब इफ नेचर हैज क्रिएटेड सो इट विल एंड इट इन सच अ मैनर। सो स्टेट ने जब एक लाइफ नहीं दी है तो हाउ कैन वी से दैट स्टेट इज आल्सो गिविंग यू अ राइट टू डाई एज वेल? ऐसा बोल नहीं सकते।
थैंक यू सर।
यस सृष्टि।
सर आई डोंट हैव एनी डाउट, बट सर एक्चुअली जब आपने यूथनेशिया पार्ट स्टार्ट किया था तो आई गॉट डिस्कनेक्टेड फॉर द फर्स्ट केस, द विजय केस, तो कैन यू प्लीज रिपीट दैट, हाउ टू स्टार्ट द यूथनेशिया पार्ट?
विजय केस में I told you that for every right to speak under article 19(1) it was said that there is a right to remain silent, ठीक है, because the state is giving you right, so first a right to speak has right to silence. They used the same part in P. Rathnam. They said that since in article 19 it clearly says that there is right to receive, sorry, in article 19 since it says that there is right in right to speech, there is right to remain silence. In the same manner in article 21, since there is a right to life, there is a right to die.
Okay sir, can you please repeat the full name of the case? I just missed it.
Achha, Vijay Emmanuel versus State of Kerala.
Yes sir. Thank you sir.
Yes Mansi.
Sir, I have a doubt. Breeding equipment will come under passive euthanasia or not?
What equipment?
Breeding equipment.
Removing the breeding equipment. That will come under passive.
Sir, first example you have gave when we started the euthanasia case. So in that example you said na the person is a brain dead, so doctor took out the breeding equipment, it was then he died, so it will come under culpable homicide. Sir, it is completely wrong, I think so at the end.
Pardon?
It won't come
under
it won't come under culpable homicide, right na?
No,
299 तो नहीं आएगा ना उस केस में।
It will come under culpable homicide if you have not taken his permission and you have not taken it, you have done it with involuntary act.
Involuntary consent लेंगे तो वो फॉल नहीं करेगा, consent नहीं लेंगे तो वो फॉल करेगा।
हाँ तो फॉल, ठीक है।
Okay sir.
Yes Ishita.
Sir, I have an out of context question. May I ask?
Yeah, ask.
So, कुछ cases में we often come across the situation whereby hospital में if somebody dies, then doctors they don't declare him to be dead. और उसको बेड पे ही लिटा के रखते हैं फॉर लाइक डेज 2 to 3 days, जिससे कि बिल बढ़ता रहे, तो सर उस केस में हॉस्पिटल की क्या लाइबिलिटी होगी?
आपको सिविल लाइबिलिटी करनी पड़ेगी, या तो
मतलब
चीटिंग के लिए डाल
क्रिमिनल में कोई नहीं है
चीटिंग
उनका?
चीटिंग के लिए डाल सकते हो, पुट देम फॉर चीटिंग, बट
Okay.
एंड सिविल लाइबिलिटी।
मतलब ऐसा कुछ पनिशेबिलिटी नहीं है क्रिमिनल?
चीटिंग में बहुत है वैसे तो, 7 साल तक की 420, अगर आप बोलो कि पैसे इतने ले
तो
लिए।
चीटिंग से सीवियर नहीं है कुछ मतलब?
हाँ, सीवियर नहीं है उससे।
ओके सर।
यस पवित्र।
Sir, I have doubt in the previous topic, sir.
Which one? Kalani Godan.
So suppose circumstance.
Circumstances. Ask. पूछो.
Sir, one second, sir. Sir, here, one second, sir. In that Sarathi case, sir, while discussing it, you told no, sir, like if there is recklessness in the act which led to the actor's fears, that means the court will impute knowledge, sir.
Yes.
So this knowledge will be imputed, but you also said the knowledge will only be imputed in section 299, sir.
3, correct.
So the knowledge will not be imputed in 304, even though there has been reckless act, sir.
Yeah, the reckless act itself makes it punishable. No? The scope of knowledge is not there in 304. You are not required to prove knowledge in 304.
Okay, sir.
Only recklessness you are required to prove.
Okay, sir. Sir, I also have one doubt, another doubt, which is also out of context, sir. It is about the present topic, sir.
Ask.
Sir, do you think that this law is effective, sir? Because as I think, due to the conditions of Indians as of now, this long process of passive euthanasia is not possible, sir. So I think they may defy law in many circumstances where they would act over passive euthanasia. Yeah, it may happen, sir.
They do. That is the thing that they have introduced another concept which is known as living will. Have you heard about it?
Living death, sir.
Living will.
Living will, sir.
Living will mein, what you will do, you will write that if I die, so if I get into a permanent vegetative state, then in that case, this fellow, he will be my nominee and he can give consent on my behalf for passive euthanasia. So this is a valid concept. So you can do that, but for that also they have made guidelines very difficult. You'll have to register this living will with the district magistrate.
Okay, sir. So where there are many frauds are happening now, sir.
Yeah.
People this act over both are happening now, sir.
Yeah, true.
Okay.
Yes, Aditi.
सर मुझे ये पूछना था कि किन केसेस में जो कमेटी बैठती है पैसिव यूथनेशिया में, तो वो किन केसेस में वो नहीं उसको अलाउ करेंगे? ऐसा क्या वो देखेंगे जिससे वो ये एप्लीकेशन को रिजेक्ट कर देंगे?
अरुणा शानबाग में नहीं अलाउ किया था कमेटी बैठ के।
सर नहीं अलाउ किया था?
हमें जजमेंट मिली बट दे डिड नॉट अलाउ।
सर क्यों नहीं किया था?
Because पहले तो contention ये था कि since the first thing was that they didn't allow her euthanasia because there was no family member and there was a doctor who Pinky Chandwani or something her name was. She was fighting a case for a long time. Then even in the committee they said that there are some chances, so it wasn't allowed actually.
बट सर अरुणा शानबाग वाले केस को बहुत ज्यादा टाइम हो गया था और कोई भी रिकवरी के चांसेस नहीं थे, तो फिर क्यों उन्होंने किया? मतलब बहुत इलॉजिकल सा नहीं उन्होंने बेसिस पे मना कर दिया?
They didn't allow even in this judgment Aruna Shanbag they did even in this judgment 2011 they allowed passive euthanasia, but they said that we would expect the relatives of Aruna Shanbag to approach, not Pinky. So
sir अभी भी Aruna Shanbag is in vegetative state.
Yeah, sorry, Pinky Virani, she's a journalist, correct. Pinky Virani, she's a journalist, she was not doctor. I don't know about the present situation, मुझे अभी पता नहीं. She died actually. कितना टाइम हुआ? She died, I remember.
So she died, I guess 2-3 years back.
हाँ, 2-3 years. एक न्यूज़पेपर में पहला देखा.
Yes sir, she died naturally.
Naturally she died.
Yes sir.
Passive euthanasia नहीं मिला था.
सर और रेस्ट कौन से केसेस में मतलब क्या देख के मना करते हैं? इसमें तो
मतलब ऐसे
चलो
कोई नहीं,
क्लोज फैमिली को
क्लोज
बोल
फैमिली
दिया।
भी नहीं थी, और उसके उसमें ये भी नहीं था ना, पिंकी विरानी थी, शी वाज अ जर्नलिस्ट, सो उसमें केयर टेकर भी अलाउड नहीं कर रहे हैं यहाँ पर, तो दिस थिंग दे हैव क्लोज्ड, जो एप्लीकेशन है, द पर्सन हु विल अप्लाई दैट इज वेरी लिमिटेड, ये प्रॉब्लमेटिक सिचुएशन।
ओके सर।
यस मोहित।
Sir, in Sarthi case, in the second situation where there is no negligence, we will refer to the original mens rea, right, sir?
Yeah.
In case, sir, for example, in the facts of Buddha versus State, where there was no mens rea at all. So, in case there is no negligence and no mens rea as well, so the accused will be exempted.
No
right,
liability.
sir?
No liability. Correct.
And sir, secondly, sir, the knowledge that we were imputing in this Sarthi case, that was only limited to section 299 subsection 3.
Yeah.
Sir, why cannot be imputed the same knowledge with reference to section 300 subsection 4?
That's a higher degree of knowledge. In all probabilities, it caused death, and that is of he did not know that the act is eminently dangerous. So it's a
So, sir,
very
can we
highest
do
degree.
that, sir?
No,
Sir,
we
if
cannot.
the facts allow,
We
like
cannot
for
do.
example, if the person throws
You can do. You cannot do that. You can do only if you have the knowledge that this fellow is alive and you are sure about it. So that in that case, 304 is applicable. Or 304 is the highest degree of knowledge. You cannot impute that knowledge. You have to
So,
establish that.
So, sir, any condition in these kind of situations, it won't apply.
It won't apply.
Okay, sir, thank you.
Yes, Anshika.
Sir, I have one question irrespective of IPC. Can I ask?
Pucho.
Sir, in between of the class, you were telling about the bench, full bench and everything. So there is one doubt, sir. Sir, usually after constitutional bench, the bench is in the odd numbers, right, sir?
After constitution, 3 bench and then 2 is also there.
Sir, 5 bench के बाद 7 और ऐसे.
नहीं, 6 bench पे हुई है. तहसीलदार वर्सेस स्टेट ऑफ यूपी 6 judges bench.
Okay, sir. So
Rarely होते हैं, but होते हैं.
Okay, sir. So it can happen like 8.
It can happen. Rarely होता है. 4 judges bench में मैंने आपको पढ़ाई एविडेंस में एक केस है. तो rarely होते हैं, but happens.
So sir, 8 judges bench भी हो सकता है, right?
8 judges bench हुआ भी है. आपका पुट्टुस्वामी जजमेंट के सतीश चंद्र वाला जजमेंट वो 8 judges था.
Okay, sir. Thank you, sir.
पुट्टुस्वामी was 9 judges जिन्होंने ओवररूल किया उसको.
Okay, sir. Okay.
ठीक है. सतीश चंद्र was 8 judges bench मेरे साथ 1959. Yes, Aditi.
Sir, if you are exhausted, then I can ask in next class. मेरा 149 से related question.
वो next class में पूछो. Next class में पूछो. Yes, Ishita. You say.
Okay, sir. No problem.
Sir, theory of supposed circumstances से है एक problem.
पूछो.
So actually एक problem पढ़ा था जिसमें it was like there were 4 members A, B, C, D and they like beated X rigorously. मतलब उसको मारना ही चाहते थे kind of. तो believing him to be dead, they left them and leave from that place. Subsequently थोड़ी देर बाद A आता है उसको मतलब शॉट करता है मतलब गन से. तो उसकी जो डेथ होती है वो गन शॉट की वजह से होती है. तो सर
A only one person comes. A only comes, ना?
वापस सिर्फ एक ही आता है. A ही आता है.
Only A will be held liable.
सर यहाँ पे अगर चारों लोगों का like if they intended to kill him and believing him to be dead अगर वहीं पे छोड़कर आ गए तो उनकी liability नहीं बनेगी क्योंकि initial
बट एक्टर्स रियस साथ में नहीं किया ना. जो सब्सिक्वेंट एक्टर्स रियस है वो साथ में नहीं किया ना, एक ही बंदे ने किया. तो एक ही बंदे की आपको लायबिलिटी इंप्यूट करनी पड़ेगी इनिशियल पे.
तो सर बाकी तीनों की लायबिलिटी क्या होगी?
बी और सी को आप ग्रीवियस हर्ट या हर्ट के लिए डालोगे, ए को डालोगे उसके लिए.
सर इवन दो देयर इंटेंशन वाज टू किल लेकिन वो नहीं मरे थे उनके एक्ट के लिए तो दे वोंट बी लायबल फॉर.
और इवन इन जो सब्सिक्वेंट एक्ट है उसमें कॉम्प्लीमेंटैरिटी भी नहीं दिखी.
ओके, ही केम ऑल अलोन.
हां, ही केम ऑल. उसमें अगर कॉम्प्लीमेंटैरिटी होगी तो अलग बात है. तो ये विल बी.
ओके सर, थैंक यू सो मच.
यस सर. सर
नो डाउट्स एज सच. ये बता दीजिए कि आईपीसी कब तक कंप्लीट होगा?
अभी रुको, पहले कल मंडे मतलब वेडनेसडे से पता चल जाएगा हमें, बट अभी स्पीड चल रहा है.
मतलब सर मेरे साथ ये हो गया कि मेरा रजिस्टर फिनिश हो गया तो मैं तो उस हिसाब से पूछ रही हूँ कि
खरीद लो एक और.
जितना भी लिखा है इतना और रहता है क्या?
इतना एक और रजिस्टर लगेगा, आधा मतलब इसका लगेगा, मतलब समझो कि वी हैव कंप्लीटेड एक्चुअली 70%, 30% इज रिमेनिंग। जो वो बाकी के जो टॉपिक्स हैं वो जल्दी जल्दी हो जाएंगे। दीस आर द जो मेजर चंक है, एक्सेप्शंस एक मेजर चंक है, उसको थोड़ा मतलब इट विल टेक अराउंड 1 to 2 क्लासेस। ठीक है,
ठीक है सर, ठीक है।
यस अंशिका।
सर एक एमसीक्यू है, पूछ लूँ क्या?
किसका है? आईपीसी?
यस सर।
नहीं, अरे बस चलो। यस मानसी, आपका डाउट है कुछ?
यस सर।
पूछो।
सर अगर सपोज फैमिली फाइनेंशियली वेल साउंड नहीं है और कोई उनका ही जो रिलेटिव आई मीन जो पेशेंट है वो कोमा में है, तो एट द एंड अगर एक टाइम में आ जाता है ना कि अब हम पैसा लगा नहीं सकते वाला कंडीशन, तो वो पेशेंट को वो लाइफ सपोर्ट सिस्टम से हटाकर सीधा घर ले जाते हैं, वो घर में जाकर उसकी डेथ हो जाती है।
तो कर नहीं सकते ना, लाइफ सपोर्ट सिस्टम से आप हटा ही नहीं सकते किसी को।
नहीं सर, जैसे कि आज होता है ना कि कोई इंसान वेंटिलेटर में जाता है तो हॉस्पिटल वाले ऑब्वियसली चार्जेस रहते हैं पर डे, बहुत हाई कॉस्ट रहता है उसका भी। अगर फैमिली अफोर्ड ही नहीं कर पा रही है
तो उनको बोलते हैं कि गवर्नमेंट में आप किसी बेड का इंतजाम करो। वो प्राइवेट हॉस्पिटल ही आपको वो बोलेगा, रिकमेंड करेगा कि दिस पर्सन रिक्वायर्स बेड और इतना नेग्लिजिबल चार्जेस पे गवर्नमेंट पे वो कर दो। दे देमसेल्फ विल एडवाइज यू, वो आपको खुद रिकमेंड करके देते हैं। दे वोंट आपके पास ये अथॉरिटी नहीं, इवन इफ दे आर ट्रांसफरिंग। एक ऑब्लिगेशन है हॉस्पिटल के पास, जब ऐसा पीएसवी आता है तो इवन व्हेन दे आर ट्रांसफरिंग they will have to maintain in their record that they are transferring it to other hospital। ऐसे नहीं घर पे आप ला गए। ठीक है,
ओके सर,
चलिए,
थैंक यू सर,
बाय गाइस,
थैंक यू सर।
थैंक यू सर।
गुड नाइट
Sir,
गाइस। हाँ जी,
not one doubt, sir. In the Aruna case, was she in a government hospital, sir?
she was in a government hospital, KEM.
Okay, sir. No, because you tell me, so if they are not affordable, they can move to.
She was there for 40 years, around 40 years, 60s हो गए थे, around 42 years.
Okay, sir. Thank you, sir.
ठीक है, बाय गाइस,
गुड नाइट।
गुड नाइट।
Thank you so much, sir. It was a wonderful
Thank you,
session.
sir.
Bye
थैंक
sir.
यू।
Good night.
ड्रिफ्ट नहीं हुए हम, ऐसा मत सोचना ड्रिफ्ट हो गए, वी वर देयर एट द पॉइंट। ठीक है,
नहीं सर, बहुत
बहुत
मजा आया।
इंटरेस्टिंग
चलो
क्लास।
चलो, बाय गाइस।